Hi, my name is Rob Szyba. I'm a partner at Seyfarth Shaw's New York City office and a member of the firm's Appellate group. I'm going to be your host for today's episode of Decoding Appeals. And today we have one of our partners from our other office, Dawn Solowey, who will introduce herself in a moment, to talk about some of the early stages of appeals as part of our Decoding Appeals vidcast series. Dawn, welcome to today's episode.
Thanks so much, Rob. It's great to be doing this with you. My name, as Rob said, is Dawn Solowey, and I am a partner in our Boston office, and I am one of the co-chairs of the firm's Appellate team.
So, Dawn, thanks so much for taking the time to chat with us today. One of the first things that we'd like to chat about, maybe a little bit, is the critical first considerations of any appeal seem to be the timing and the deadlines that are involved. Obviously, missing a filing deadline early on can have a fatal impact on the chances of an appeal, and oftentimes the appellate rules involve strict and tight deadlines for specific next steps. As an appellate lawyer, beyond just looking up the dates and seeing what the deadlines are, what else is on your mind as part of the appellate process? What are you thinking about?
Yeah, I think I'm primarily thinking that the clock is ticking. Time is of the essence when it comes to the early stages of post-trial motions and appeals, because the clock will start the minute that judgment enters. And sometimes that can be, a jury returns its verdict and the judgment is entering that same hour. And so there's a really tight deadline for filing post-trial motions, and it's really important to preserve any appellate issues in those motions. And then there's usually a short track to the deadline to file any notice of appeal. So, I think one of the first things that our clients, the in-house counsel, needs to think about is, who is the team going to be for those post-trial motions and appeal? Is it going to be the same trial team or litigation team that handled the issue below? Certainly, they're going to know the record and they will have lived through the case. But do they have the appellate experience, which is sort of a unique skill set to take the case to that next level? There may sometimes be value in having a fresh set of eyes, especially if this a decision came down that is like a bet the company decision, a high profile decision, an explosive verdict, which of course are more and more common. And so sometimes it will be a combination of the appellate counsel with the trial or litigation team from below. So I think one of the first things to think about is the clock is ticking and who is going to be the team that is going to kind of jump in, roll up their sleeves and get into it.
It sounds, sorry to jump in, but it sounds
Yeah.
like from what you're describing is if you're at the point where you have an adverse decision and you're starting to think about these issues, you're already behind the eight ball. Because, at least in my experience, these deadlines tend to be a matter of days, sometimes 7, 14, 21, usually not more than 30 for any type of appellate submissions. And sometimes it's not just a notice of appeal, sometimes there are interim steps and things that you have to do to be able to appeal even. So, I mean, you're talking about assembling a team and making sure you have appellate counsel on hand. To me, it sounds like the thing that, these decisions are things that you would be thinking about before these events even happen so that you can hit the ground running immediately.
I think that's exactly right. And I think that there's so much that has to get done in those first days after the judgment has entered. One is that whoever's going to be doing the post-trial motions and the appeal needs to have the record right away in hand, right? So, for the in-house point of view, they're going to need to facilitate getting that record to whoever is going to be handling those appellate issues. So, the judgment, the verdict form, the parties' proposed verdict forms, the jury charge that went to the jury and the parties' proposed charges. All of that material needs to get into the hands of the appellate team, and transcripts have to be ordered if they haven't already. And sometimes we have the luxury of daily transcripts, which is great. But if not, then it can take a bit to get the transcripts from the court reporter. And so it's really sort of facilitating, as the in-house counsel, the transfer of all of that knowledge and all of those pleadings into the hands of the appellate counsel so they can start thinking about, the appellate issues. And, like I said, transfer of knowledge. It's also, making sure that the trial counsel or the litigation team is coordinating with whoever the appellate team is going to be to, help give some insights into, where does the trial counsel think that the most damaging errors occurred? Where did things go wrong below in terms of the court's rulings? And then the appellate team really needs to kind of roll up their sleeves and start reading the pleadings and those transcripts. Because in my experience, there's no substitute for actually reading those transcripts and getting the full flavor of what happened and where those errors were.
I think we have these experiences from time to time where, we're at an event, we're at a court hearing, we're at a deposition, we're at something that results in the transcript. Some time passes, we look at the transcript, and it totally does not match what our recollection is. And I think, to your point, one of the important things, to kind of remember is that the appellate court and the clerks are going to just be relying on the written record. They're not going to have the benefit of having been there, of having seen it, knowing what the inflections were. They're working off the, off the transcript or off whatever the written submissions were. So to some extent, I think it's valuable for appellate counsel to look at that with a fresh set of eyes. The transfer of knowledge is critically important, obviously, but to have that, to look at it from the perspective of what the appellate clerks or judges are going to be looking at in sort of that vacuum that they're going to be existing in. You also kind of made me chuckle a little bit for a moment when you said, getting the transcript, and all I can think of is Murphy's Law. Of course, the day that you need the expedited transcript, something comes up, something happens. All these things are real examples, and they happen from time to time where you need an expedited transcript, but something happens with the court reporter. There's some gaffe that happens, and you have to be ready for that. Those are things that are not hypotheticals.
Yeah, no, absolutely. And it's funny you say that about the transcripts, because I remember one of my mentors saying the transcript is never as good or as bad as how you remember it. And
Right.
it's really true. I think, it's such an important point about getting a fresh set of eyes on what happened. And I find in particular with looking at appellate preservation, just was something, because often in the trial counsel's mind, something was preserved. But when you look at that transcript and you're really looking for it, it's not always as clean and crisp as, one might hope. And so I think there's a lot of value, and it's really that pairing of, the people who were there in the courtroom below kind of have one set of perspective on the record, and then the appellate counsel come in with a new, fresh set of eyes as to, the issues and, where things went wrong if there was a bad ruling.
Right. So now that we've thought a little bit about the timing and some of these initial moving parts that are involved in preparing an appeal, one thing to point out is that not all appellate courts work the same way. The same way that trial courts are different from one jurisdiction to another, one state to another. They all have their own sets of rules, local rules, even at times judges' individual preferences and sort of the chamber's rules. So appellate courts tend to have their own rules the same way, with their own procedures, nuances, and from time to time, you even come across these sort of unwritten traditions that appellate courts follow that unless you've been in that courthouse 100 times, you really wouldn't know. So what do you recommend for an appellant who is facing a potential appeal in whether it's a new jurisdiction or even a jurisdiction they've been in 100 times, but you want to make sure your bases are covered? What would you recommend?
It's such a great point. It's really kind of a labyrinth in a lot of cases as to the different appellate rules. And as you said, sometimes it's not even rules. It's not something that's written down anywhere. It's just sort of the way the circuit works. So I think it's a combination. It's making sure that certainly that the appellate team is researching the rules. One thing that our appellate team has done is to develop detailed process maps, sort of flow charts, for every circuit, so that we can very easily see, what is due when, and if this happens, then this happens next. And that's been a great tool for, again, because time is of the essence, being able to kind of just know those answers, quickly and right off the bat. I think it's also a recognition that it's certainly true that the appellant has the initial burden of filing, the notice of appeal and some of those early deadlines. But it's just as important for the responding party to be aware of what those rules are, both to make sure that they don't miss what they have to do, but also to make sure that they're kind of keeping the appellant on track. Sometimes that falls to us to kind of say, hey, isn't it time for us to have done X? So we always want to be proactive about that, no matter which side of the appeal we're on.
One of the things too that you mentioned was the way the different circuits work, to add to the fun, if you will, when you factor in state court appellate process, that can really run the gamut. I practice a lot in New York, and for example, some of the courts have, procedures and processes at the appellate departments, that are just very unique. And unless you're accustomed to some of that practice, they're definitely not what I would consider intuitive. But those are sort of the nuances that you oftentimes need to know and can be critical for your appeal, because I'll give you a great example. Even something as simple as the time to appeal starting to run, there are certain proceedings where you have to file a notice of entry. You have to, after something's been filed, you have to file a second document to confirm that the first document was filed. Until then, the notice of the notice of appeal would be untimely, or the notice to appeal wouldn't, the time to appeal wouldn't even start running. So it's interesting because not just the circuit courts that have some uniformity, and I'll tell you my other little secret, which is relying on some of the case managers. If you have a good case manager on your appeal, oh man, that is great, worth their weight in gold.
And I think having those relationships, right,
of course,
with the clerks, that's certainly true here in Massachusetts as well. The personal relationships, so you can pick up the phone and say, here's this kind of quirky situation, we're proposing to do, X, what do you think? And kind of getting guidance from these clerks, some of whom have been there for, decades,
right,
and know all of the intricacies of how things work. And so having that personal connection can really be a benefit.
Make a huge difference. Huge difference. So we've thought a little bit about timing and about navigating the, the morass of rules, or the labyrinth, as you referred to it. Let's talk about the appeal itself for a moment. So sometimes we joke internally that, an appeal is not really a mulligan. It's not just a do-over of whatever argument that you had at the trial court. It's really a different and altogether, different process, different venue, altogether. How does your approach differ on an appeal from your approach at the trial court level?
I actually think that this is one of the most misunderstood aspects of appellate practice. You will sometimes hear people, say, well, there isn't really much work to do on the appeal because we already briefed summary judgment. And that is really not the way to think about how to build an appeal. I think one of the most important decision points in both post-trial motions, and especially the appellate stage, is which arguments you will select for appeal. Meaning that you're not going to just argue every single thing that you argued below. That kind of sort of kitchen sink approach is almost never going to be the right one. Partly just for really practical reasons. Like, you've got pretty limited space in an appellate brief and a lot of stuff you've got to do in that space. You may have 10 or 15 minutes in an oral argument if you even get one. And so, it's really about picking the arguments that are going to have the most likelihood of success and spending your focused time on those. And I would usually start by looking at, the standards of review, because, you're going to want to focus on arguments to the extent you can that have a favorable standard of review. So, some issues are going to have a de novo standard, which means that the court will look completely fresh at those arguments, purely legal arguments or errors like in the jury charge, whether punitive damages have been excessive. Whereas evidentiary rulings are typically, much more discretionary, and so therefore much less likely to be overturned. Sometimes you can play with those standards a little bit. Sometimes an unfavorable standard can be turned into a more favorable one. So, it might be an evidentiary ruling, which would normally be kind of an abuse of discretion standard, but there may be a way to attack like the legal standard that the court used and therefore get de novo review. So there can be some creativity involved in that. But you really want to look at those standards of review for selecting appellate issues. And then also like just practical things like, did it matter? Did that error make a difference in the outcome? And how much money is that error worth, right? Like that, if you were to win on that particular argument on appeal, what's the dollar value associated with it? And what kind of procedural remedy can you get? Are you going to get a completely new legal ruling, or are you just going to get a new trial? And how does the client feel about that? So kind of thinking about all of those issues to make really strategic and smart decisions about what to include in the appeal.
That makes a lot of sense. And along those lines, about the substantive aspect of the appeal, let's talk a little bit about, let's say you presented an argument at the trial court and lost. Now you're appealing. We're not, copying and pasting the brief. As you said, it's not just, we wrote the brief already, let's just submit it again. How would you describe your approach to framing the argument versus how you might have presented the argument below?
Yeah, I think it's a really good question. I think it's really about kind of thinking about the audience. The appellate court is just a totally different audience from the lower court. The appellate judges have to think about things like, what are the public policy implications if I were to agree with you? What's the effect on other cases? I'm an employment lawyer, so how would this affect other cases in say Massachusetts or in the First Circuit if we were to adopt your reasoning? And those issues may have had some role in the lower court's thinking, but the appellate court is certainly looking at those issues at a much sort of higher level. And so it's really important to make sure you're framing your arguments in those ways. Like, what are the logical implications of your argument or your opponent's argument, right? It might be sort of saying, look, Your Honor, if you adopt, opposing counsel's point of view, it's going to lead to all of these public policy issues or all of these downstream effects on, other employment cases, other businesses, other employers. So I think that's a perfect example of how you're not just filing the same brief and that you're really, thinking about the issues differently. Also, what have other states done? What have other circuits done? Because appellate courts will usually be very interested in, before we take a stand on this, how have some of our sister courts or neighboring states, looked at similar issues?
I think that's a really, really important point about sort of the perspective. And from the circuit perspective, you might be talking about a handful of states or a certain region of the country that's going to be a lot more of an impact than just on this individual case, this individual litigant, these individual parties, or even this, oftentimes even the state. So I think that is an incredibly important point to keep the audience in mind as to the arguments that we're presenting. So let's talk about a few additional practical considerations. We've been talking about some of these, big picture, big items. But in some ways, appeals require a lot of cooperation from the parties in presenting to an appellate court. It might not be as adversarial of a process as, for example, trials or trial court litigation. And what comes to mind is presenting a joint appendix or a joint record. What are your thoughts on this sort of cooperative aspects of the appellate process?
Yeah, I think that's a great point. I mean, I know in my practice, I really try to sort of reach out early on to say, let's do this cooperatively, and because it's so much more efficient. And I will actually offer often to sort of take the lead in assembling that joint appendix, which often opposing counsel is happy to sort of take you up on. And it has the advantage of allowing us to just make sure that it's done efficiently and correctly. Obviously you need to check the rules to make sure that you're only including what is allowed. And you also never want to over designate so that, the court does not want to read 50 million pages in the appendix. And so, trying to sort of work cooperatively to try to just get that done. And it saves so much time and money for both of the parties and the court. If you can agree on, kind of an efficient appendix together.
Another practical consideration that comes to mind is some of the submission requirements. What I mean by that is, unlike trial courts, appellate courts tend to have very specific requirements for the number of copies, the colors of the covers to the briefs that you're supposed to use based on who's submitting, and all kinds of very specific nuanced rules. What's your recommendation for navigating some of these very specific submission requirements?
Honestly, years ago, I moved to exclusively using an outside appellate printer, because as you said, there are just so many, rules. And if in a lot of courts, if you break one of those rules, the brief is not compliant and it gets bounced, which definitely no one wants.
No one wants.
So the appellate printer they're going to get all those details right. And they also just serve as a, professional editor, basically. Somebody who has not been looking at the same brief, a million times in the last 30 days and, can spot, those kind of proofreading issues. But also just all of the, the font and the word count and the typeface. And there's a lot of kind of landmines there. And I just find that it's such a good investment to, use an appellate printer. That's one of my first calls as soon as I know when the brief is due, is to get on the list of the printer. And it just ends up basically being less attorney time and less paralegal time, and therefore saves the client money. And it always produces a really polished result.
And I think you kind of breezed over that comment real quick, but fonts, font size, margins, word counts are very strict rules in some jurisdictions with some appellate courts. Those issues alone, the wrong color brief, the wrong color to the cover to your brief can alone be, a very impactful mistake to make. And at least in my experience, a lot of times the appellate printers will have former clerks, former, appellate lawyers that are on staff that will help guide through that process. And to your point, can be an incredibly useful resource. But these, it's so funny to be talking about, like, the very specific word counts, or, is this 12-point or 13-point or 14-point font? But at this level, at this practice, that matters a lot.
It does. I mean, they'll be bounced if they're not compliant. So, absolutely. It's just, it's peace of mind to, to get the printer lined up.
So let me skip ahead a little bit in the appellate process, because we're talking about a lot of considerations that we have at the beginning of the process. But, one thing that I always like to think about is, where are we going? It's great to think about these things that are happening now, but what's the end goal? And several steps down the road, we may be having oral argument. What do you think about, when do you start preparing for oral argument, or how do you start thinking about oral argument, even from the initial stages of the appeal, whether or not it may happen, and despite the fact that it might be months or multiple steps away? What are some of the things that you like to lay the groundwork with for oral argument, even starting from day one?
Yeah, I think it's a great point because, oral argument is just so short. It's, generally 10 or 15 minutes max. And so you really have to know what your arguments are, what your themes are, and be able to articulate them really clearly and really efficiently. And, you have to be ready for either, a really quiet bench or a really hot bench where you might not have, I think, sometimes people's inclination is to create these like lengthy outlines, 20 pages, as if they're going to be up there for, an hour and a half, working meticulously through their outline, when that's just not really how it works in real life. And so I think, I think if you're in-house counsel, you want to make sure that you are communicating with the appellate team about what the high level thematic big picture points are. Because, whoever's arguing the appeal will almost certainly have the ability to frame those quickly at the beginning and quickly in closing, and kind of having agreement and alignment on what those big picture issues are. And I think also just, making sure that you organize a moot of the argument so that, you get to kind of try out those themes and workshop those a little bit. And, I know what we always do with our team is, create sort of lists of the hardest possible questions you can think of. What are the biggest challenges for our appeal? What are some of those public policy questions, or other hard questions, and actually practice, doing those in the moot setting. So those would be sort of my high level tips.
Yeah, and one thing I'll add to that is an oral argument is not just a spoken version of your brief. Oftentimes, it's the opportunity to answer questions, like you said, and any concerns that the court might have, especially when it comes to those policy arguments or any ambiguities, adverse cases, developments. It is an incredible opportunity, but to your point, requires a tremendous amount of preparation. I would say, starts with day one, knowing sort of where you're heading. It's becoming obvious that this is a whole different thought process and approach to appellate practice as opposed to, the trial court practice. As lawyers litigate cases, what do you recommend for trial lawyers so that potential appellate issues are sort of preserved and captured for appeal?
Yeah, I think about this a lot because I'm a trial lawyer. My practice sort of focuses on trials and appeals. So, it's really being prepared at trial to have a strategy for appellate preservation. I know in our Trial Advocacy Institute, where we train associates, in trial practice, we have a whole session on appellate preservation. I always have my appellate preservation checklist right next to me at the counsel table, just so that I'm sort of checking things off as I go. And sometimes our trial lawyers will have someone from our appellate team either consulting, sometimes in the courtroom, or back at the office as a resource to make sure that issues are preserved.
That's an important point. Any final thoughts before we wrap up for today?
I would say, for in-house counsel, just making sure that you really focus on communication with the appellate team. As to your expectations for the appeal, are you looking to settle? A lot of courts will have settlement processes early on in the appellate system. And are they looking to settle, or are they looking to sort of take this all the way and get an appellate ruling? And really just make sure you're sort of communicating about strategy as you go, from the issue selection all the way to the oral argument. I think that's the best chance for success.
Well, Dawn, thanks so much for the opportunity to chat with you today about some of these important issues on appeal and some of the different considerations that go into the appellate process, appellate issues that come up, and sort of the considerations that in-house counsel and clients have to make when considering appeals. Thank you so much for your time, and we really appreciate your insights.
Yeah, thanks so much for having me. This is fun.
Absolutely. And thanks so much to our listeners at home. We really appreciate your attendance and checking out this episode of our vidcast. Stay tuned and keep an eye out for additional episodes of the Decoding Appeals vidcast series presented from Seyfarth Shaw's Appellate Group. Thanks so much.